Hello, everybody. Hello and welcome to today's webinar. My name is Dan Totillo. I'm with Wolters Kluwer, and before we begin today's webinar, I just wanted to cover a few quick housekeeping items. From the very beginning, everybody is on mute as you first entered into the meeting, but please use the menu bar that's located on the Go to Webinar menu. That's generally on the right side of the screen to submit your questions. So throughout the webinar, I actually will be the person who's monitoring your questions as they come in. And as they come in, I'll answer via chat, or we'll actually just hold on to the end and cover all the questions with the presenters and the moderator at the end of the presentation. Also, speaking of the end of the presentation, we will be sending out a PowerPoint and white paper at the end that covers all of these slides, as well as the white paper that gives even more details about what we'll be discussing today. And with that said, I'll pass this over to our moderator, Jenna Ellis, who will be speaking with Nicole and Danielle. Jenna?
Hi, thanks, Dan. So I wanted to welcome everyone again to our What Are the Experts Saying, the contraceptive mandate in the wake of Hobby Lobby. Thank you so much for joining us. As Dan mentioned, I'm Jenna Ellis, and along with Dan Totillo, we are your moderators today. And I also wanted to welcome our two experts, Nicole and Danielle. They are our experts and featured speakers. Nicole Stone is a director of the Health Reform Knowledge Center, and she's the senior managing editor for the Health Law Division at Wolters Kluwer Law and Business. Her areas of content expertise include healthcare reimbursement, coding and billing, and health reform. Prior to joining Wolters Kluwer, she was an associate attorney at a medical malpractice law firm, and she focused on physician practice defense. And we also have Danielle Capella. She's a senior writer analyst in the health law area for Wolters Kluwer Law and Business. Danielle's the lead editor of Wolters Kluwer Health Law blog and the senior writer and analyst of the Health Reform WK Edge, Health Law Daily, Food, Drug, and Cosmetic Law reports, and the Medical Devices report. So thank you so much, and welcome Nicole and Danielle.
Thank you.
Thank you. All right, so let's start. And the first slide I have is just kind of is an overview. The Hobby Lobby decision is kind of the first thing we're going to tackle, and the exemption from providing contraceptive coverage that was granted to Hobby Lobby on the grounds of being the closely held corporation with this sincerely held religious belief. But as of yet, we'll also talk that closely held corporation has not been specifically defined on the federal level. And then another area that we'll get into is the Wheaton Injunction and how the Supreme Court granted Wheaton College the injunction from being required to fill out the Form 700 as a substantial burden. And of course that this injunction is specific to Wheaton College only. So the first slide that I want to put up then after this overview is kind of the foundational history of why this contraceptive coverage became such a hot legal issue, and one of the reasons we're all here. So this is the first time that this type of coverage is mandated, and Danielle, in the past, couldn't employers just not offer contraceptive coverage as part of their plan?
Absolutely, Jenna. Before the ACA, some states required contraceptive coverage, but generally speaking, health insurance wasn't particularly uniform across the U.S. The ACA had an entire list of what they call preventative health services that all insurance plans are required to include in their plans. This includes colorectal screenings, mammograms, and for women, it includes a mandatory contraception coverage.
Great. So then I think that leads us right up to Hobby Lobby and kind of the procedural history of this case. Danielle, do you want to go over that?
Absolutely. When the contraceptive mandate came down, which required employers to include contraception as part of their employee health benefits that they offered, quite a few corporations across the United States were very upset by this. Hobby Lobby, which is closely held, it's a family-owned national craft chain, they filed for an injunction with the district court. They claimed that they were a person under the Religious Freedom Restoration Act, which was a bipartisan act passed some years ago. And by being a person under the Religious Freedom Restoration Act, they argued that they were substantially burdened by having to provide the contraceptive coverage. They specifically objected to the IUD and emergency contraception, not all forms. And they found that those drugs are not acceptable under their religious beliefs, so they asked the court for an injunction. Initially, the court denied the injunction. It found that for-profit corporations are not people, that they can't have religious beliefs. And they found that coverage for the employees of the business is the actual impact of the mandate, so it was an indirect burden on Hobby Lobby.
Okay, and I think that then leads us up to the 10th Circuit. And why did the 10th Circuit deny the injunction?
The 10th Circuit agreed with the district court ruling when they heard it in December of 2012. It was heard before 3 judges on the 10th Circuit, and they issued a ruling that was substantially similar to the district court ruling before, that a corporation just is not protected under the Religious Freedom Restoration Act.
Okay, and I think we have the next slide that about June 2013.
Yes, the case is following just a natural progression on the calendar. Hobby Lobby still was not happy with the decision that came out of the 10th Circuit, and so they asked for an en banc hearing. This is really rare. They're basically saying to the court, this is such an important issue, this is such a big deal, that rather than have our case heard by just 3 judges, we want our case heard by all of the judges that are members of the 10th Circuit. These are rarely asked for and even more rarely granted, but on this go-around, the 10th Circuit decided to hear it again in front of the entire panel of judges. And in what was somewhat of a surprise ruling, they went ahead and reversed its original decision and remanded the case back to the district court, essentially telling the district court, here's what we think, and what we think is that the Religious Freedom Restoration Act doesn't specifically include for-profit organizations, so it could include them. So you need to re-rule on this case, taking this into consideration. And obviously, when it went back to the district court, they did what the 10th Circuit told them to do, and they granted Hobby Lobby an injunction.
Okay, and so also kind of interesting is that concurrently, I think Conestoga Wood is being heard then in the 3rd Circuit, and the final result seems to be kind of opposite of how Hobby Lobby was decided. Is that right?
You're correct. As Hobby Lobby was filing its lawsuit, quite a few other corporations, somewhat similarly structured to Hobby Lobby, were filing similar lawsuits. They were holding that they were small, they were family-owned. The families that owned them had strong religious beliefs that didn't agree with either all birth control or some forms of birth control. And these cases began making their way through the system. A lot were dismissed right away. A lot were held. Some other circuits kind of held their decisions back, waiting to see what would happen, because it became inevitable that this circuit split would happen. The circuit split did happen. The 3rd Circuit ruled in the opposite direction as the 10th Circuit, and the injunction was denied to the Conestoga Wood Corporation, which is also a small family-held company.
Okay. And so I think that leads us to back to Hobby Lobby and the Supreme Court. Nicole, I think you want to discuss that.
Correct. So in November of 2013, the Supreme Court agreed to hear the Hobby Lobby case at the federal government's request. In February of 2014, briefs were filed by both parties, as well as by both the Republican and Democratic parties at that time. In March, oral arguments occurred. And what's particularly interesting about the oral arguments is that the Supreme Court justices had no shortage of questions for the attorneys. They came right out the gate and started asking questions, which is typically unheard of. And so the justices touched on the often discussed potential fallout of a decision in favor of Hobby Lobby as it would relate to other medical treatment that has been historically met with disapproval from certain religious entities. This would include, the medical treatment would include things like vaccines, blood transfusions, products made of pork like heart valves, etc. And Justice Kagan was specifically concerned that the evaluation of each treatment on its own could lead to a piecemeal approach, which would essentially lack uniformity across the United States, likely leading to further litigation down the road. Justice Kagan also noted that there could be a parade of horribles if employers were allowed to apply religious exemptions to pre-existing statutes. This would potentially lead to religious objections to sexual orientation, minimum wage laws, child labor laws, and gender equality. So in July of 2014, the Supreme Court handed down their decision. And this was a 5-4 decision, and they did rule in favor of Hobby Lobby. So the majority decision, which was written by Alito, stated that the contraception mandate could not be applied to for-profit corporations with religious objections to some of the contraception methods. The court ruled that the mandate does violate the Religious Freedom Restoration Act, as the mandate is not the least restrictive means by which to further the interests of the government with regard to women's health. The court rejected the government's arguments that the corporate employers were separate from their owners and that the for-profit organizations do not exercise religion. In fact, the court reasoned that the corporate form exists to protect the human beings who create them, and the Corporation Act only through those human beings. Therefore, closely held for-profit corporations with sincerely held religious beliefs are now being considered persons under the Religious Freedom Restoration Act, which means they do have protection under that particular act. So what's interesting is that at the same, within this particular opinion, Justice Kennedy issued a concurring opinion, and he went on to discuss the slippery slope that could occur following this decision. So he stressed that the majority was only ruling on the contraception coverage mandate and that the logic of the case should not be extended to other medical procedures, such as those blood transfusions, vaccines, etc. In addition, he stated that the Religious Freedom Restoration Act could not be used as a backdoor means to evade anti-discrimination laws, thereby trying to head off, he was essentially trying to head off that parade of horribles that Justice Kagan originally discussed during the oral argument. So at this same time, there was a dissent that was written by Justice Ginsburg. And Ginsburg, this dissent gained very quick public notoriety due to its criticism of the majority opinion. Ginsburg accused the majority of stepping into a minefield by its immoderate reading of the Religious Freedom Restoration Act and characterized the decision as one of startling breadth, allowing commercial enterprises to opt out of any law, saving for the tax laws, a judge incompatible with their sincerely held religious beliefs. And according to Ginsburg, the exemption sought by Hobby Lobby would override the significant interests of the employees and their dependents and deny legions of women who do not hold their employer's beliefs access to contraception coverage that the Affordable Care Act would otherwise secure.
So what I also got out, Nicole, when we were originally talking about this decision, and what I found interesting is also the concept of the closely held corporation and what they said about that, and also the lack of the federal definition of that issue.
Absolutely.
Or of that term.
Right, exactly. So the court stated that the closely held corporations who have significant or who have sincere religious beliefs are essentially that they may be exempt from the mandate. However, the court failed to actually define what a closely held corporation is. So some could assume that a family-owned corporation would qualify as it would have a similar corporate structure to Hobby Lobby. However, that would purely be an assumption. And this has left essentially Health and Human Services to try to figure out the definition, which they are right now seeking comments on in a proposed rule, which Danielle is going to discuss further in a few minutes. So the key takeaway, though, is that no corporation should assume they would or would not be considered closely held and therefore exempt from the contraception mandate until the definition is published. And the one exception, though, I will say is that corporations that qualify as a religious employer under the Internal Revenue Code, those employers have always had an exemption to the contraception mandate under the Affordable Care Act. Therefore, they do not need to worry about the definition of closely held.
Right. Okay, and I think that that actually is a kind of a good segue for us to talk then about Wheaton College. So post-Hobby Lobby decision, if you will, Wheaton College already had this IRS religious exemption. So, what did the request that this, what was the request that this injunction was based on? And another thing that I think is interesting is procedurally, how did this even get to the Supreme Court?
Sure, I can talk about that. Essentially, at the same time that some smaller corporations were fighting against the contraception mandate, some employers that were already considered a religious employer under the Internal Revenue Code were taking issue with essentially the process by which they had to go through to get their exemption. HHS set up a process for religious employers to fill out an EBSA Form 700. It's a one-page form. And when they filled that out and submitted it, it was basically their way of letting HHS and their third-party administrator know that, hey, I'm a religious employer. We do not plan on providing contraception to our employees at no cost. This form would then trigger their third-party administrator, the company handling their health benefits, to come up with basically a system on the side so that employees of the religious employer, if they filled a prescription for contraception, they would still not pay a copay, and the cost would be picked up by the third-party administrator. HHS thought that this was an acceptable accommodation for religious employers, but religious employers across the country filed lawsuits alleging that the form that they were asked to fill out, the act of filling out the form, was a substantial burden, that the IRS already knew that they were a religious employer, and that by filling out the form that they were being burdened and their rights were being stepped on. The day after the decision came down in Hobby Lobby, the Supreme Court issued an injunction. It only affects Wheaton College, saying that Wheaton College did not have to fill out the EBSA Form 700, essentially because HHS and their third-party administrator were already aware of their status, and they didn't need to go through the process of filling out the form. The decision by the Supreme Court was once again filed with a dissent. Justice Ginsburg used very strong words once again, essentially saying, this is what I was talking about in my opinion yesterday. I think this is a slippery slope we're heading down. And just really strongly disagreed with the majority ruling of the court. But that is the only EBSA Form 700 case that the Supreme Court has quote-unquote heard, and because it was just an injunction request, they didn't hear the full merits of the case. So the full issue of the form has not been argued before the Supreme Court.
And I think we have EBS Form 700 here on this next slide, just to take a look at it. Just see, yep, there we go.
Here you go. So this is the form that religious employers were being asked to fill out. It's pretty simple: name of the organization, name and title of the individual who is authorized to make the certification, and then a mailing and email address of the individual.
And actually, can I interrupt with a question? This is Dan. One of the questions that's been posed was, it fits right here. Does this apply? This injunction was just for Wheaton College, or does this apply for any religious employer? Or
this applies to just Wheaton College. There are some other EBSA Form 700 cases floating out there at a pretty high level. There's one going on in Colorado. There are some others as well. So, I think that it's a matter of time before this issue works its way up for full argument before the Supreme Court. It might not happen in this term, but never say never.
And was it any kind of a sign that they did it right after Hobby Lobby, or do they think it was just, is there any kind of theory on that, or is it just sort of that's what happened?
Well, injunction requests are kind of by their nature somewhat emergent. An individual or a corporation is coming forward and saying, we need something done by the court and we need it done right now to protect us. So they do tend to be heard pretty quickly. It was a little bit surprising that the Supreme Court ruled on it. If you read the dissent, if you read the injunction, the order allowing the injunction, which essentially says we have a circuit split here. We've got different courts doing different things with these forms. That's why we're go ahead and granting this. Then if you read the dissent says a split like that, a disagreement like that has never been the basis for us granting an injunction. Basically we don't know what the other justices are talking about. It's kind of an interesting study in contrast to read both one after another.
Great, thank you. So I think then we're back to some proposed rules after this form. HHS proposed rules.
Correct. In some other cases that are ongoing, essentially in a court filing, HHS said, don't worry, we don't need to keep litigating this at this moment, because this year we're going to issue some regulations and some guidance on how to deal with the Hobby Lobby decision. That happened at the end of August of this year, and they issued 2 documents side by side on the same day. The first one was a proposed rule. It was open for comments, and the proposed rule was outlining essentially different ways to define closely held corporation and asking for input from the industry and the public to comment on the proposed ways of defining a closely held corporation. And on the same day, they issued an interim final rule, and the interim final rule went back to deal with the religious employers, such as Wheaton College, and basically really strengthening the process in dealing with employers of nonprofit religious organizations to ensure that the employees had access to birth control coverage, but that the employer wasn't paying for it. Now, it is worth noting that's an interim final rule, so logically we might see for lack of a better phrase, a final rule on that. And then obviously for the proposed rule, in some time frame that is somewhat defined but kind of loosely followed, HHS will take all of the comments into consideration and use those comments to formulate the regulations that come out in the final rule. And it could take a while. There could be another interim final rule. Every now and again they reopen the comment period. Occasionally they issue a revised proposed rule. So, you know, the time frame on that has a bit of a question mark, but at the end of the day, we should see two final rules, one for the definition of a closely held corporation and one for the nonprofit religious organizations.
Great. And so then on the horizon, you kind of talked about it already, but anything else then on the horizon for Hobby Lobby and for religious employers?
Well, I think that we're going to see a lot of back and forth until the final rules do come out. I wouldn't be surprised to see an extension of a comment period or you know, intermittent documents before the final rule comes out. And this EBSA Form 700 issue is still floating out there, and I just don't think we've seen the last of it. The case in Colorado is ripe and poised for continuing up to the Supreme Court. So, you know, while the court is in session, you know, pay attention to those filings.
Yeah. So then if you were an attorney, or how could someone advising clients then keep current? It seems like there's a whole bunch of dates coming up. And so how does someone then keep current with all of this information? Right?
Well, we have a couple of different products at Wolters Kluwer. One is a State Compare Smart Chart for contraception coverage. It's going to give you both the federal and the state issues. It's updated weekly. So, for instance, here it's highlighting California just recently updated its state regulation to kind of mirror the federal regulations regarding contraception coverage. The big difference that it makes in the state is it's making the contraception mandate applies now to the state Medicaid program. It did not in the past. So this chart is a great way to stay on top of things. We also have our Health Reform Edge, which has a weekly email that goes out with kind of anything that's happened in the week, and it also has a significant number of tools, a regulatory tracking calendar, etc. So all of these are going to be great ways to kind of stay on top of what's going on.
Okay, great. And so really important just to watch the federal government and related developments in the states. Exactly. Okay. So I have a couple other kind of wrap-up slides here. So, and Danielle or Nicole, if one of you wants to address kind of these questions that we were asking of what to consider if you're asked by an employer. One of you want to tackle those?
So if you are a religious organization or you are representing a religious organization, a question that commonly comes up, and which I think Dan brought up even earlier, but I'll just restate, is a lot of people are wondering whether they have to fill out the EBSA Form 700 right now. Because the Wheaton College Injunction only applies to Wheaton College, right now you must still fill out the EBSA Form 700. Unless you are an organization that has filed litigation and a temporary or other type of injunction has been issued for you. So with that specifically said, you want to make sure that you are, you know, talking with your third-party administrator and that you are properly filling out that form so that it can be captured by HHS. And another question that comes up a lot is, am I, as an employer, or do I represent an employer who is considered a closely held corporation? And this is really, this is one of the biggest questions out there right now in the industry. This is why HHS has put out that proposed rule and is asking for comment. They have several different scenarios that they have proposed with regard to what a closely held corporation could be. And I would highly recommend that if you are a corporation that you think could qualify as a closely held corporation, or you represent an employer who you think would fall into this category, I would highly recommend taking a look at that proposed rule and potentially even commenting on it so that you can, apply your perspective for HHS. But for now, you would be making an assumption if you were to consider yourself a closely held corporation, essentially if you're anyone other than Hobby Lobby. So, right now you still have to make sure that you are complying with the contraception mandate as it pertains to the health benefits that you offer your employees. And this actually relates right to the last bullet point on the screen, because as of January 1st, 2015, if you're an employer who has 100 or more employees, and that would be full-time employees, then you will receive a tax if you do not comply with the minimum essential health benefits requirement of the Affordable Care Act. Now, the minimum essential health benefits requirement essentially means that you have to provide certain kinds of health benefits to your employees. Among those benefits is contraception coverage. And so if you do not offer contraception coverage and you are an employer of this size, and it is after January 1st of 2015, you could then receive the tax. And so this is really where you want to have your third-party administrator basically on speed dial. You want to make sure that you're talking to them regularly, that you have a plan in place for how you're going to handle specifically contraception coverage, but also all of your health benefit coverage after January 1st, 2015. Now, if you are an employer who has between 50 and 99 employees, you get a little bit of a waiver. So you do not have to worry about that tax until January 1st of 2016. That came out earlier this year in new regulations that were released. And so you can kind of sit back and see really what happens, and hopefully by the time it comes to you, there will be a definition of what closely held is, and there will be a process in place for you to be able to opt out if that is applicable.
Great. Thank you so much. Dan, do we have any other, I know you were answering questions during and talking a little bit about some of them, but do we have any other questions that came in chat?
No, actually, all the questions were about ESBA 700 and, of course, about the slides. We will be sending, I'll just reiterate, we had a couple of questions from folks asking if we'll send the slides. We will, along with a white paper that details a lot of this information, so we will be sending all of that. But those were the only questions.
Great. So then I wanted to thank everyone for attending. We appreciate it. And I also really want to thank our experts, Danielle and Nicole, and we appreciated your time and your knowledge. Again, just as Dan said, if you have any other additional questions, there is my email address. Please feel free to reach out. And the slides and also a great white paper will be coming to you via email after the meeting. So thank you, Danielle and Nicole, and thank you, everyone attending.
Thank you.
Bye-bye.
Thank you.
Thanks, everybody.